I hope you are able to see the screen now. Yes. So what has been happening with the disqualification, the Rahul Gandhi case? We have Lalu Prasad Yadav as well. So we'll start with the basic meaning and definition, and then we'll move on to what has been happening in the news and what has been happening with Rahul Gandhi, and the grounds on which the disqualification is there, and what happens when a MP or an MLA is disqualified, and what happens if and how they are disqualified, the grounds on which they are disqualified. We'll discuss those things. We'll also discuss the laws which are connected and related to this disqualification of MPs and MLAs. So let's start with today's discussion. So first and foremost, the disqualification, the meaning of disqualification. So basically, disqualification is a situation or a fact that means you are not allowed to able or participate in something. So that is the basic meaning of disqualification. Okay. So wherever happens a situation is there, or there is a fact that is happening, or something happens where you know due to which there is something called where you are disqualified by law, or where you are not able to participate in the proceedings, or the as a member of parliament, or as a member of legislative assembly, that is basically called as the disqualification. So coming down to the legal provisions of disqualification in India. So in India there are 2-3 laws in which the disqualification is dealt. Can you name which are those laws? Please do comment which are those laws, and then we can definitely go and start the discussion on what are the actual grounds of disqualification. In the screen, you can see Article 102, definitely. So that deals with disqualification of an MP. Apart from this, do you know any other laws? Yes. So come on guys, I want this to be an interactive session. So it just doesn't have to be a one-sided conversation from me. So I want it to be more interactive. I want you to give answers. Even if the answers are wrong, I don't mind. You are here to learn, right? So just give your answers, no matter if it is right, it is wrong, no issues. So yeah. So starting with Article 102, in the meanwhile, do let me know in the comment and what are the other laws or what are the other provisions that deals with the disqualification of an MP or an MLA. So in the meanwhile, I'll start with Article 102. So this particular article deals with the disqualification of an MP. So it reads that a person shall be disqualified for being chosen as or and for being the member of either of the House of the Parliament. One. Uh, yeah. Raja Bulani. Raja, my volume from my side is completely, I think, full. I am also holding my mic. So I think maybe if you can turn your volume from your side, I'll think that will be helpful. Yeah, I am trying to speak into the mic, and I think that from my end it is working fine. Even if there is a problem, just let me know, or if you can turn up your volume, I think that will solve your problem. So yes. Okay. So what I'll do is I'll also turn off my camera so that you can concentrate on the PPT itself. Yes. So coming back to the thing where Raja, I hope I'm audible now. Yeah. So coming back to the disqualification, that is Article 102. So here, disqualification of an MP, when we talk about the disqualification of an MP, we see that Article 102 deals with it. And here, just a second. Yeah. So Article 102 deals with the ground of disqualification of an MP. So it says that a person shall be disqualified for being chosen as or for being a member of either of the House of the Parliament. So there are five grounds. First is uh, that if he holds an office of profit with the government of India or with the government of any state, or other than that he an office declared by the Parliament of law or by law, not to be disqualify its holder. So that is the first ground. The second ground is if he or she is of unsound mind. So that is the second ground. Or if he's declared, if he's declared stand to be by like if he is declared of unsound mind by a competent court. So that becomes the second ground. So the third ground is if he is discharged and insolvent. So if he becomes an undischarged insolvent. So I hope you know what is undischarged insolvent. If not, so undischarged insolvent is basically where you are declared insolvent, but your insolvency or the status of your insolvency is not yet been discharged. So that is called as undischarged insolvent. So wherever this thing happens, that is called as the undischarged as an undischarged insolvent. So here in such cases, if you become an undischarged insolvent, that becomes a ground for disqualification. Then we come down to the fourth ground, that is if he is not a citizen of India or has voluntarily acquired a citizenship of a foreign state or is under any acknowledgement of allegiance of adherence to foreign state. So wherever he loses his his citizenship, so there it becomes a ground for disqualification. And then the last ground, that is the if he is so disqualified by or under any other law made by the Parliament. So these are the basic five grounds on which an MP can be declared disqualified. So apart from these five grounds, so here the most important provision or the most important ground that we are going to talk about today is the fifth ground, that is if he is disqualified by any other law or under any other law made by the Parliament. So coming down to the explanation of this particular provision, that is for the purpose of this clause, the person shall not be deemed to hold any office of profit under the government of India or the government of any state by the reason only that he is a minister of either of the such union or such state. So what happens is where he holds the office of profit, there it becomes a ground for disqualification. But if he's appointed as a minister of a particular department, say for example a home minister or the foreign minister, if he's holding that office, that does not become a ground for his disqualification. So other than these ministers post, if he is holding any other office of profit, then that becomes a ground. But if he's minister, it does not become a ground. So coming down to the second provision of this particular article, so that is article, which article? So it is article 102. So we are talking about the disqualification of MP. In that we are talking about article 102 and clause 2. So clause 2 says that a person shall be disqualified for being a member of either house of the Parliament if he or she is disqualified under the 10th schedule. So do you know what is 10th schedule? Yes, Twinkle, you are asking that could I please explain office of profit? Okay. So office of profit is basically where you are in a position that holds or which gains profit from dealing with the government. Or say for example, if there is a if there is a MP who has a cement factory and there is a contract from the government that we need so and so bags of cement, and this particular MP supplies those cement, so that is an office of profit where this particular thing or where this MP can gain from that particular transaction. And if he is if he or that if that MP is in a position where he can give that contract to his own company, that becomes an office of profit. So in such cases it definitely becomes a ground for disqualification. So that is not legal or that is not ethical for the representation like the representative or the MP or the MLA to do. So that becomes a ground. But where he is a minister and he does not hold any other businesses or anything else, so if he's minister, if he's say for example if he is the foreign minister or if he is the defense minister, the best example I can give. If he's the defense minister, he is getting into contract with other countries or with other states for buying, buying defense supplies or getting defense supplies delivered. So if that is a contract and this he is a minister, the defense minister, then that is not an office of profit, because he himself is not getting any profit out of this particular contract or buying, defense stuff from various other countries. So that is not an office of profit, but where he himself is gaining some profit out of that transaction, then that becomes an office of profit. So yeah, coming down to the second clause of Article 102, which says that a person shall be disqualified for being a member of either of the House of the Parliament if he or she is so disqualified under the 10th schedule. So the two things that we are going to talk about today, or that we are going to focus today, is one is this, that is E, that is the fifth ground, that if he or she is disqualified by or under any other law made by the Parliament, and second is the 10th schedule. So do you know what is the 10th schedule to the Constitution? If yes, then do let me know in the comment. In the meanwhile, I'll start with the next provision, that is Article 191. So Article 191 deals with the disqualification of an MLA. So Article 102 dealt with the disqualification of an MP, and this particular provision, that is Article 191, deals with disqualification of an MLA. So yes, Twinkle, that is absolutely correct. 10th schedule deals with the Antidefection Law. Yes. So coming down to Article 191, this is also a very similar provision that we read earlier, that is Article 102. So Article 102 and Article 191 is a very similar provision in altogether. The only difference is that this particular provision, that is Article 191, deals with the disqualification of an MLA, whereas Article 102 deals with the disqualification of an MP. So that is the basic difference. Apart from that, if you can see that in the first ground, that is clause A, there is also a difference. There is another difference there. So these are the two only difference. So if you see Article 102, so the first clause, that is the A, it read that if he holds any office of profit under the government of India or the government of any state other than the office declared by the Parliament by law, not to disqualify its holder. So that was clause 1 or clause A. So here in Article 191, this clause A reads as, if he holds any office of profit under the government of India or the government of any state specified in the first schedule other than an office declared by the state by law, not to disqualify its holder. So the only difference is there, it was in general any office of profit under the government of India or the government of any state. Here it becomes restricted to what is defined in the first schedule. So that is the difference. So that is the first ground, again office of profit. So coming to the second ground, that is B, that if he or she is of unsound mind and stands so declared by a competent court. Now to the third ground, that if he or she is an undischarged insolvent. The fourth ground, if he or she is not a citizen of India or has voluntarily acquired the citizenship of a foreign country. So the fifth ground, if he or she is so disqualified by any other law made by the Parliament. So these are the same grounds as we can see earlier in the Article 102. The explanation is also the same. The second provision, that is the second clause, that is Article 191 clause 2, this also reads the same, that a person shall be disqualified for being a member of the Legislative Assembly or the Legislative Council of the state if he or she is declared disqualified under the 10th schedule. So yes, so in totality, if we compare both Article 102 and Article 191, so these includes majorly 6 grounds on which a MP or an MLA can be disqualified. So the first one is holding an office of profit. As I have told you what is an office of profit, I hope you are able to understand So if any MP or on an MLA is holding an office of profit, he that becomes a ground for his disqualification. Now coming to the next round, that is being incompetent or of unsound mind. So if he becomes an incompetent in any capacity, or if he becomes a person with an unsound mind, and that has to be declared by a competent court, then that becomes a ground for disqualification. Now coming to the third ground, that is he's declared undischarged insolvent. The fourth ground, that he is lacking the legal citizenship. Fifth ground, disqualified by any other law made by the parliament. And the sixth ground, disqualified by that under the 10th schedule. So these are the grounds on which a MP or an MLA can be disqualified. If you want, you can definitely take a screenshot of this, and for future references, if you have an exam like CLAT PG and everything. So in any exam, if there is a question that what are the grounds, or which of the following grounds MP or an MLA can be disqualified under Article 102 on 191. So these are the basic grounds on which an MP or an MLA can be disqualified. If you want, you can definitely take a screenshot of this. So coming down to the anti-defection law. Yeah, even if you're preparing Bablu, right? So if you're even if you're preparing for CLAT UG, this is something that you should know. The grounds for disqualification, this you should definitely know. In UG, the difference between the papers of UG and PG is that in UG, the questions are more theoretical and conceptual. The application of law is asked, like you have been, like you are given a law, a situation on which you have to apply that logic and you have to apply that law and answer the question. In on a contrary, when you are preparing for CLAT PG, the questions are more based on the cases that are happening, on what did the court say in so and so cases, so or the provisions itself. So directly, the direct questions on provision, the situation based questions on the case laws that have been happening recently, so those questions are there. So if even if you are preparing for UG or PG, this is a topic that you should definitely go through once. At least you know what has been happening, so that will help you for preparing for your exam. And yes, I also have a surprise for you. I have something special for you, both for UG and PG. Definitely stay with me till the end of this particular live. I'll definitely show you something that will help you for preparing your with your CLAT UG paper or your CLAT PG paper. So coming back to the slides, that is the anti-defection law. So this particular law, that is the anti-defection law, was given in the 10th schedule. So this 10th schedule is also known as anti-defection law, and this particular schedule itself deals with the disqualification on the ground of defection by the elected representative. So do you know what is defection? If you know, do let me know in the comment. So in the meanwhile, so defection is basically where a member who switches their political party to another political party after being elected as a member of a particular party, that is basically called as defection. Yes, Twinkle, Vijay Mala did fall in the insolvent category. Yes. Coming back to the slides, so defection. So when a member is elected from a particular party, say for example, if he is contesting the election with a ticket from the Congress, after getting elected, he switches his party and goes and joins the BJP or some other party, say for example NCP or something else. So here what happens is he got selected or elected by a single party, then he switches to different parties. So that is called defection. So if this continuously, if this defection is happening, so once I'm selected from one party, then I switch to another party, then I switch to third party, then I switch to fourth party. So if this is happening, so there is no stability in the government, and to maintain that stability, there is this law that is called anti-defection law. So when was this anti-defection law introduced? This particular law was introduced by the 52nd amendment Okay, the 52nd constitutional amendment in 1985, this law was introduced. So before this, that is before the introduction of this particular amendment, that is the 52nd amendment in the year 1985, there was uh, approx in 1970s 75. So there was a major defection in the parliament. So I think you must have heard that there was a saying that ayaram gayaram. So that particular ayaram gayaram, the entire saying came from defection. There was an MP by the name of Ram. So he was continuously switching parties and defecting the entire parliament. So the basic the muhavra became ayaram gayaram. So whenever he came to a party, they were saying ayaram. Then when he did defection and went and joined another party, so they were saying gayaram. So that was the saying that were there. So that became very famous, and accordingly this that became the very ground on which the defection was made, the anti-defection law was made. So that was introduced in the year 1985 by the 52nd amendment, and accordingly the 10th schedule was incorporated and inserted in the constitution. So this 10th, particularly 10th schedule, lays down the guidelines and the procedures to be followed in a case of a defection, including the process of disqualification of a member who is defected. So that is what this particular law is all about. Coming to the next law, that is the Representation of Peoples Act 1951. So this is another act where defection where on which there are grounds for disqualification of an MP or an MLA. So this particular act is an act to provide the conduct of election of the houses of parliament or the houses of state legislature. So if it is a state legislature, if it is the central government, the house of parliament, whichever house, this particular act, that is the Representation of Peoples Act, this particular act provides the ground on which how the elections are to be conducted, or how the members are to be selected, or how the parties are to be formed, which parties get what's like the rights and duties of a political party and everything. So all this is mentioned in this particular act. So this is an act which is also deals with the qualification and disqualification of the membership of the houses, the corrupt and illegal practices and other offences, or in connection with such elections and decisions of the doubt disputes arising out of the connections of everything that is there about the either of the house of parliament or the house of state legislature. So all these things are discussed and uh, you know dealt by this particular act, that is the Representation of Peoples Act. So that is the act. Coming down to the provisions of our disqualification in this particular law. So these are the provisions in which a particular MP or an MLA can be disqualified in this particular law, that is the Representation of Peoples Act. So what are these sections? So the first section is section 8. Section 8 deals about or talks about the disqualification on conviction for certain offenses. So just remember this particular section, that is section 8. I'll talk to you about section 8 in my coming slides. So that is section 8 talks about disqualification of on conviction for certain offenses. Now section 8A says or talks about disqualification on the grounds of corrupt practices. Now section 9 deals with disqualification for dismissal or corruption for disloyalty. Section 9A talks about disqualification for government contracts. Now section 10 talks about disqualification for office under the government company. Section 10A talks about disqualification for failure to lodge account of election expenses. Section 11A talks about disqualification arising out of conviction and corrupt practice. So these are the provisions. Now if you are asked a question about what are the grounds for disqualification under the Representation of Peoples Act, so you go to section 8 and give the grounds. These are the grounds out of which if a question is asked on if an MLA or MP was convicted for so many years, or he was given an imprisonment of, punishment of imprisonment for more than 2 years. So there you go to section 8. Accordingly, if you are asked a question based on any of these provisions, these are the sections on the Representation of People's Act that you should know and you should keep in mind while reading this particular act, as these are the grounds on which a MP or an MLA can be disqualified. So that is the grounds for disqualification under this provision. So coming down to the Rahul Gandhi case. So what happened in this case? So the facts of this case are very simple. So during the election in the Karnataka rally, so there was an election rally in the Karnataka in the month of April 2019. So Rahul Gandhi there made a remark that why do all thieves have the surname Modi? So he just said कि पता नहीं क्यों but हर चोर का नाम मोदी ही होता है. So that was the remark that he made. And the very next day, a BJP leader named as Purnesh Modi filed a complaint before the Chief Judicial Magistrate Surat, and accordingly he framed it for against Rahul Gandhi for defaming people with the surname Modi. So that was the defamation case filed by the Purnesh Modi. So that was the case in which Rahul Gandhi was held and sentenced. So what did the court held in this case? So it was held that Rahul Gandhi was found guilty of section 499 and 500 of IPC. Now what is section 499 and 500 of IPC? Section 499 and 500 of IPC is basically defamation. So wherever you are defaming a person, or a defamation suit is filed against you, that is filed against section 499 and 500 of IPC. So these two provisions talks about defamation, and accordingly Rahul Gandhi was charged with this provision, that is 499 and 500, and accordingly he was held convicted. So he was held guilty and convicted in this particular case. Accordingly he was sentenced to 2 years of jail, where he was also given a fine of 15,000. So this is what that is happened in the Rahul Gandhi case. Now coming to what led to his disqualification. So if you remember that I asked you to remember section 8. Section 8 talks about places or disqualification of conviction of for certain offences. So section 8 of Representation of People's Act says that if a person, if an MP or an MLA is imprisoned, or if he is convicted and imprisoned for more than 2 years, so that becomes a ground for disqualification. And yes, as in the comments Twinkle said that yes, since he was sentenced for 2 years and more, so since he was sentenced for 2 years, and that became a ground in which he got disqualified, and accordingly that was the provision. So now what happened? So after his disqualification, since it was the Chief Judicial Magistrate, so he went to the Sessions Court. Okay, so Rahul Gandhi went to the Sessions Court to put a stay order on his conviction and his sentence in the Sessions Court Surat. So there his application got dismissed. So again now what he can do is he can go to the High Court, and if there also his application is rejected, then he can go to the Supreme Court. But if this particular application is rejected both by this the High Court and the Supreme Court, then that is definitely his his end in the political career, as this particular law says that if he's convicted for 2 years or more, so this particular section, that is section 8, talks about where this particular MP or a MLA who got convicted for more than 2 years, he is disqualified immediately, and after he has served his sentence, he cannot join back the political party, or he cannot be elected for the next 6 years. So say for example, if it is 2023 right now, so if he goes into prison in this particular year, or even if by the end of this year, so till 2025 he will be in prison. After 2025, for the next 6 years, he cannot participate in any political party, or he cannot participate in any elections from any political party. So that is what this particular law says, and accordingly that is what has been happening with Rahul Gandhi. Now, coming to a few case laws for defection. So, the first case that we are going to discuss today is Kihoto Holohan versus Zashilu. So, this case is of Supreme Court in the year 1992. So, this particular case, that is the Kihoto Holohan case, talks about where several petitions were contested for the constitutionality of Schedule 10 and the 52nd Constitutional Amendment of 1982. So, this particular case was filed challenging the constitutionality of the 10th schedule and the amendment by which this particular 10th schedule was added. So, after the challenge of this particular schedule and its yeah, Twinkle, 6 years after completing the prison sentence. So yes, after completing his prison sentence, that is, if he is imprisoned for 2 years, and if he goes into imprisonment in this particular year, that is 2023, after completing his imprisonment for 2 years in 2025, after that he won't be allowed to get into political parties or get into elections for the next 6 years. So from 2025, if he goes into imprisonment right now, then after 2025 the 6 years, and then he can again participate. So yes, so coming back to the Kyoto Holon case, so in this particular case what happened was schedule 10 and the amendment, the constitutional amendment, that is the 52nd constitutional amendment, was challenged in the Supreme Court, and accordingly the Supreme Court maintained that 10 schedule is absolutely legal and there is no doubt about it. And although the court also pointed out that since although the speaker's decision to disqualify a particular MP or an MLA, so a chairman or the speaker can disqualify the MP or an MLA. So if that particular decision, that is the speaker's or the chairman's decision, is though very much final and binding, but at the same time it is not exempted from the judicial review. So if there is if there is a need to take into consideration the grounds on which he was disqualified and everything, so definitely that can be done by the court under the purview of judicial review. So yes, so coming to the next case, that is the SR Bomai versus Union of India. Do you know this case? This is a very famous case in constitutional law. Yes, coming down to the SR Bomai case. The SR Bomai case says that in 1994, the Supreme Court of India held that the power to disqualify a person from being the member of parliament or member of legislative assembly under section 8 of the Representation of People's Act was a quasi-judicial power that had to be exercised fairly and impartially. So this particular case, that is the SR Bobai case, this particular case talks about section 8 and the powers of section 8 to be a quasi judicial powers, and that power has to be applied and exercised very fairly and impartially. So the powers given under section 8 shall be exercised very fairly and impartially. So that is what was held in the SR Bomai case. So SR Bomai versus Union of India. Now coming down to the third case, that is the Lily Thomas case. So this case is of 2013, which was there in the Supreme Court. This particular case talks about where the Supreme Court ruled that section 8 subsection 4 of the Representation of People's Act 1951 is unconstitutional. This section allowed the MPs and the MLA to continue in office if the conviction was resolved. So until if there was an appeal against this conviction, so there the MPs and the MLAs were able to continue to their office. This is what section 8 subsection 4 said, and the Supreme Court in this particular case, that is the Lily Thomas case, held that this is absolutely wrong and this is very unconstitutional. So accordingly they struck down section 8 subsection 4 from the act itself, so the Representation of People's Act. So that is what was held in this particular case. So the court also stated that if an MP or an MLA is convicted for 2 or more years, they would be disqualified immediately. So this is the case on which, on based on which, the disqualification of Rahul Gandhi was immediate. So this is the case. Say, like, this is the case where the disqualification, the ground for disqualification, if any person or any MP or MLA is convicted for 2 years or more, so he should be disqualified immediately, is what was held in this particular case, and accordingly the immediate disqualification of Rahul Gandhi is based on this case. So that is what the law says. Now, coming down to the next case, that is the Ashwini Kumar Upadhyay versus Union of India. So this is one of the most recent cases, that is a case of 2021. This is also a case from the Supreme Court. So in this case, what happened was the Supreme Court ordered the central government to speed up the establishment of special courts for trying the cases of MPs and MLAs, including the cases related to disqualification of MPs and MLAs. So this is what was happened, or what was held in this particular case, that is the Ashwini Kumar Upadhyay case. So that was all about disqualification. Now coming down to something I think you should definitely know, and something more interactive. So I would like to ask you a few questions on which I would like to see answers. So yes, coming down to the questions, let's play a game. Let's test your knowledge. So these are a few people or a few MPs and MLAs, and these are a few cases. All these people or all these MPs MLAs were disqualified related to some or the other conviction in some or the other case. So let's play a game of who was disqualified in which case, or a conviction for which case. Yes, Twinkle. That is actually a very funny thing. I also saw that video that Rahul Gandhi had actually torn the ordinance of the Lily Thomas case. Yes. Coming down to this game, can anybody tell me that why was Mohammed Faisal, who was Mohammed Faisal, and where, in which case he was convicted? Lalu Prasad Yadav and Azam Khan. Yes, Twinkle, Lalu is definitely the fodder scam case. So if we match the pace, this is absolutely correct. So do you know who Mohammed Faisal is and where he was convicted, in which case? Yes, Mohammed Faisal was, yes, Faisal, attempt to murder. Yes, absolutely right. Mohammed Faisal was convicted in the case of attempt to murder case. This is the most recent case. This has happened in, I think, 2023 itself, in the starting of 2023. One is, yes, Bablu, you are absolutely right. Azam Khan was convicted in the hate speech case. Mohammed Faisal was definitely convicted in the attempt to murder case, and Lalu Prasad Yadav was convicted in the fodder scams case. Now, coming down to a very quick memory test. So, based on the slides that we went through, I just have a few questions, a few MCQs which I want you to answer. So, the first question is, which article were amended along with the introduction of 10th schedule by the 52nd Amendment? So, when the 10th schedule was introduced by the 52nd Amendment, a certain laws were, a certain provisions were uh, amended. And though we have not talked about that particular amendment, But if you have seen the provisions, the slides in which the provisions were made, so those provisions, from that you can definitely guess the answer. Yes. Do you know the answer to the first question? What do you think? Is it A, Article 101 and 102? Is it B, Article 164 and Article 361B? Is it C, Article 190 and 191? Or is it D, Article 101, 102, 190 and 191? Yes, Twinkle, absolutely correct. It is option D, Article 101, 102, 190 and 191. Now, coming to the next question, that is the second question, which says that in which case the Supreme Court struck down the conditions laid in the 10th schedule that the decision of the presiding officer is not subjected to judicial review, thereby allowing appeal against the presiding officer's decision in the High Court and Supreme Court. Yes, Twinkle. Second is this. The answer to this particular question is B, Kihoto Holohan. So, we discussed the case of Kihoto Holohan, in which this particular provision that was absolutely held unconstitutional, and hence it was struck down. So, this particular thing was struck down in the case of Kihoto Holohan, and accordingly, the judicial review, this particular presiding officer's decision, the finality, or the bindingness of this presiding officer's decision was given under the judicial purview of judicial review. So that was the case, Kyoto Holohan. Now, coming to the third question, that now consider the following statements. Now, the first statement is Rahul Gandhi was found guilty of defamation under Section 499 and Section 500 of IPC. The second statement is Rahul Gandhi was disqualified as a member of Lok Sabha because he was found guilty of defamation. Now, which of them is true? Is both the statement true? Is just the statement 1 is true? Whether only the statement 2 is true? Whether both the statement are untrue? Yes. What do you think is the answer? Which of them is the correct statement? Yes. In this question, yes, Raja, you say that both are true. That is option A, right? Malvika says both are true. Okay. Anybody else? Twinkle also says that it is A, that both statements are true. Okay, anybody else want to guess the answer? Okay. So in this particular question, option B, that is statement 1 is true, is the correct answer. Now how? I'll let you know. So the first statement is Rahul Gandhi was found guilty of defamation under section 499 and 500 of IPC. This is absolutely true, as we saw in the case that we discussed, that is the Rahul Gandhi case. Now, the second statement says that Rahul Gandhi was disqualified as a member of Lok Sabha because he was found guilty of defamation. That is absolutely not true. He was not disqualified for being guilty of a defamation case. He was being disqualified for being imprisoned for more than 2 years, according to Section 8. So that is something that you know you should keep in mind. You should read again and again of what this particular statement is saying, or what is it meaning actually. So he was not disqualified for being found guilty, or he was not disqualified for being convicted in the defamation case, but the imprisonment clause, the point where he got an imprisonment for more than 2 years, that is the 2 years imprisonment. So that became the ground for his disqualification. As Twinkle earlier said in her comment, that if he was not convicted for more than 2 years, if there was he even if he was convicted in the defamation case, but if he was given a a punishment of imprisonment for 1 year or 1.5 years, he wouldn't have been disqualified. But since it was more than 2 years, or it was 2 years or more, so that became the ground. So statement 2 here that says that Rahul Gandhi was disqualified as a member of Lok Sabha as he was found guilty of the defamation case. So that is not a correct statement. So in the CLAT PG test, or even in the UG test, there are sometimes a situation given like this to just to confuse you, or just to check whether you are actually getting what you are reading, or what has been happening around you. So that is a very this kind of questions are also asked in the in the question paper of UG and PG both. So that is something you should definitely keep in your mind, where and what statement are you reading, and is it a trick question or not. So you should be very clear of what the law says, how it is applicable, and where it is applicable. So accordingly, there in this particular question, that is the only the statement 1 is true. So coming down to the fourth question. Now the fourth question says that in which case the Supreme Court held that Section 8 subsection 4 of the Representation of People Act is unconstitutional. Now there are 4 options. Yes, Twinkle asks that if it was a civil case. Yes, yes, Twinkle. If it was a civil case, but if imprisonment was a part of that particular thing. So generally what happens in civil case and criminal case, the basic difference between the civil case and criminal cases: in criminal case, you are the case is against you are there against the state. From the victim side, the state is the body which is fighting the case. So that victim just becomes a victim and basically a witness in that particular proceeding. But that case is the society represented by the state versus you. So in these cases, in criminal cases, you are definitely, if you are held guilty, you are either given a fine, or sometimes you are given imprisonment, or there is some criminal liability. And if you are criminally convicted, so this particular law, that is the Representation of People's Act, this particular law says about conviction in criminal cases or in certain offenses. So where there is an offense, that offense can only be in a criminal law and not a civil law. So there are a few instances in civil law as well where there is a criminal liability. So in such cases, the punishment for civil wrong and the criminal wrong are definitely very different. And where there is a case of civil liability, or there is a criminal liability in a civil case, so that criminal liability is very minimal. It is just for 6 months or just 1 year. So in those cases, that a conviction, so there is no conviction in a civil case first of all. And even if there is a civil wrong in which there is a criminal liability in very few cases, in those cases, if that person is is held guilty, or is if that case is against him, the decision of that particular civil case is against him, then he can be imprisoned for 6 months or so, but that does not become an offense. So that is not a ground for disqualification. So yes, coming now to the question, that is question 4. So Twinkle, Raja, and Malvika, absolutely correct. That is the particular answer for this particular question is section option A. That is the Lily Thomas versus Union of India 2013 case of Supreme Court. So this is what this particular question has the answer. So for all of you who are new to this platform or who haven't joined our course yet, I would like you to take you through our page. So these are the courses that we offer. We have a course on current affairs, we have a course on CLAT UG, we have a course on CLAT PG, we have law entrance, current affairs for law entrance. So these are the courses. This is the course page. You can definitely go through this page and check out if any of the courses is suitable for you. So if we talk about the CLAT PG course, so this is the course where we have carried everything and completed this course. So everything that is asked or whatever subject are there in the CLAT PG course, we have covered all those. So if you check this course, this is how we deal it. So the most important topics are covered in the video lectures. Then we have infographics in which there are pointers for easy to remember pointers and definitely those things. Then we have detailed notes on various topics. So this is how we cover. So people who are already there in the course, for you, I would just like you to know that if you are facing any doubts regarding the course or any subject, do reach out to us. We will definitely sit with you and solve all your queries and solve all your questions, your doubts and everything. So definitely reach out to us. You also have the support email ID with you, so definitely give us a mail, drop us a mail if you want to, and reach out to us in case you are facing any difficulties in any of the subject or any other topic. So for now, I think that was all. So here I would just end this session and uh, thank you very much for joining this session. And definitely next week we also have another session. So do stay tuned and do follow us. We will definitely send you mails and we will definitely get back to you on the topics on which we are taking the live for next week. So do stay tuned and thank you for